Thank you, Krishnan. Today I am standing in for Ms. Vaige, who was actually scheduled to deliver this lecture. She couldn't come for some various reasons. The topic given is labor law practice. So while part of our labor law paper, most of us would have done the various enactments, but when we come to practice, what is it that as a lawyer we should be looking out for when a client approaches you? So I will try to explain in as practical terms as possible how a lawyer who's faced with a client, either from a worker who might come to you or a management which is seeking any advice on issues, what should be the approach? I think by and large today my attempt, while there are several labor legislations, from your payment of gratuity, bonus, payment of wages, various other welfare legislations, I think from the point of view of a practitioner, I think the single most important enactment is the Industrial Disputes Act. So Industrial Disputes Act becomes the backbone, and I think a thorough understanding of the Act will help a practitioner to approach all other enactments, because the other enactments are less complex and deal with one particular aspect of a labor welfare issue. My attempt today is to just give a broad bird's eye view, a perspective about the way the Industrial Disputes Act is set out, the framework of the Act. And that I think will help you to give an overall understanding of how to approach any litigation with regard to labor law. Let us just take a practical example. Supposing a worker comes to you and informs you about several grievances. One, that the management has dismissed him or her from service, and please help me out. Now, I think one important historical fact which I think most labor law, persons interested in labor law should know, is that Tamil Nadu has a very peculiar tradition of one set of lawyers appearing exclusively for the working class, where they do not take up the briefs of managements to which I belong. I have come from Mr. Chandru's office, Mr. Ravan Reddy, Mr. NGR Prasad, Ms. Vaige. All of us have taken a principal stand that we will represent the working class, and so in order to avoid any conflict of interest, we have refused briefs for the managements. Similarly, there is an exclusive set of workers lawyers who exclusively appear for management. So there is this very strange demarcation which you don't find in any other states, whether for good or bad. That is a historical fact of this state. Now coming back to the provisions of the Act, if a worker comes to you, now what do you look at? I think the first question is, the three important aspects of Industrial Dispute Act is, first, whether a person concerned is a worker, whether the place of employment is an industry, and thirdly, whether the dispute with which or the problem with which the worker has approached you is an industrial dispute. So these are the three main criteria which you first have to apply your mind. So இப்போ ஒரு worker நம்ம கிட்ட வந்தா நம்ம முதல்ல கேட்க வேண்டிய கேள்வி என்ன? அவன் சொல்லுவான், நான் அதில் வேலை பண்ணிட்டு இருக்கேன்னு. சில டைம் டெசிக்னேஷன்ஸ் வச்சுட்டு நம்ம கணக்கே போடக்கூடாது. ஒரு சாதாரண கிளரிக்கல் ஒர்க்கு கூட இந்த காலத்தில் மேனேஜர், ஒரு அசிஸ்டன்ட் மேனேஜர், அசிஸ்டன்ட், ஆஃபீஸ் அசிஸ்டன்ட், இப்படி ஒரு நாமன்க்ளேச்சர் கொடுத்துருவாங்க. பட் ஐ திங்க் வி ஷுட் நாட் கெட் மிஸ்லெட் பை டெசிக்னேஷன்ஸ். ஸோ முதல்ல நம்ம ஒரு கிளைண்ட் நம்ம கிட்ட வந்த உடனே sit patiently and get details about the nature of work done by them, because the definition of worker under the Industrial Disputes Act very clearly says it should be a person who is doing either skilled, unskilled, manual, clerical, technical or operational work. So எந்த ஒரு கேட்டகரிக்குள்ள வந்தாலும் worker தான் கணக்கு. அவங்க என்ன சம்பளம் வாங்குறாங்கன்னு கணக்கே கிடையாது. For instance, a pilot, we know that all pilots today get handsome salaries, but in effect they are doing operational work. So they would become a worker under the Industrial Disputes Act. So சம்பளம் கணக்கே கிடையாது. All that is required is what is the nature of employment. So the first thing is to carefully sit down. Many of them will gloss over. See, there is a tendency, நம்ம ஊர்ல ஸ்டேட்டஸ் ரொம்ப பார்க்குறோம். ஸோ யாருக்குமே நான் ஒர்க்கர்ன்னு சொல்றதுக்கு விருப்பமே இல்லை. எல்லாருமே இல்லை மேடம் நான் மேனேஜராக தான் ஒர்க் பண்ணுறேன், நான் சூப்பர்வைசராக தான் ஒர்க் பண்ணுறேன். பட் அவங்க கிட்ட உட்கார்ந்துட்டு நீ என்ன வேலை பண்றேன்னு சொல்லி நீ காத்தால போன உடனே நீ என்ன பண்ணுவ? அப்பலேருந்து நீங்க ஒன்னொன்னா you must try to extract information from the worker to find out what is the nature of work. Then invariably you will find that they are doing either skilled, semi-skilled or clerical. They would be making entries in registers, maybe typing in data into computers. Now all this would by and large come within the definition of worker. So I think that is the first thing that you should ascertain is whether the client who has come to you is doing the work, falls within the definition of a worker. Now the next category that you should look at is the place of employment. ஸோ நம்ம கிட்ட வந்த ஒரு கிளைண்ட்டு எந்த தொழிற்சாலையில் வேலை பண்ணுறாங்க? Because unless this place of employment or the employer falls within the definition of industry, one cannot take recourse to the Industrial Disputes Act. So one needs to look at the definition of industry. Now I am not going through the definitions, I am just giving you the broad gist because I am sure all of you can take the Bare Act and read the definitions. Now as far as the definition of industry in the textbook itself is concerned, there is a little variation in how you understand it because the textbook definition has come for elaborate interpretation by the Supreme Court in what is famously known as the Bangalore Water Works case. And today it is that definition which holds the field. So நீங்க ஆக்ட்ல படிச்ச டெஃபினிஷன் பாத்தீங்கன்னாக்கா it means any business, trade or calling of employers and includes any calling, service, employment, etc. So now the issue was, if you look at trace the case laws with regard to what constitutes an industry. For instance, ஒரு ஹாஸ்பிட்டல் இண்டஸ்ட்ரியா இல்லையா? ஒரு கிளப், இப்போ நம்மளுக்கு தெரியும் ஜிம்கானா கிளப், பிரசிடென்சி கிளப், எம்ஆர்சி கிளப், ஏகப்பட்ட கிளப்ஸ் இருக்கு. இப்போ இந்த கிளப்ஸில் நிறைய தொழிலாளி ஒர்க் பண்ணிட்டு இருக்காங்க. அங்கே இருக்கிற ரெஸ்டாரண்ட்ல சர்வ் பண்றவங்க, கிளீனிங், ஸ்வீப்பர்ஸ், the cooks, all of them are there who are working. What about our temples? One of the biggest examples, these are all decided cases which have gone before the Supreme Court. One is the Tirupati Tirumala Devasthanam. What about the workers working in the Devasthanam? Now would they all be covered under the Industrial Disputes Act? This was the question which had come up across a period, and the Supreme Court had finally laid down the law waterworks case. Now the arguments of managements have invariably been, இது ஒரு ஹாஸ்பிட்டல், even it's a charitable hospital, ஒரு charitable hospital, நாங்க எந்த ஒரு தொழிலும் இங்க நடத்தல, இதுல ஒரு விதமான லாபம் வாங்கணும்னு சொல்லி எங்களுக்கு எண்ணம் இல்லை. So there is no profit motive, there is no business activity, there is no commercial activity, it is a charitable institution. So அதனால ஒரு ஹாஸ்பிட்டல் இண்டஸ்ட்ரி கிடையாது. That was one set of arguments. Clubsல, this is only a recreational center. இங்க மெம்பர்ஸ் வந்துட்டு ஒரு ஈவினிங்ல ரிலாக்ஸ் பண்றதுக்கு தான் வருவாங்க, ஒரு ஏதோ ஒரு கேம் விளையாடுவாங்க, ரிலாக்ஸ் பண்ணி ஃபேமிலியோட ஒரு டின்னர் சாப்பிட்டு போவாங்க. இதெல்லாம் நீங்க எப்படி இது ஒரு தொழிற்சாலைன்னு சொல்ல முடியும்? இது ஒரு இண்டஸ்ட்ரியே கிடையாது అని சொல்லி ஒரு வாதம் வைக்கப்பட்டது. இல்லையா, நீங்க நம்ம சென்னை கார்பரேஷன்ல ஏகப்பட்ட தொழிலாளி டெய்லி நம்மளுக்கு நம்ம பார்க்குறோம், தெருவெல்லாம் பெருக்கிறவங்க, கிளீன் பண்ணுறவங்க எல்லாருமே இருக்காங்க. ஸோ சென்னை கார்பரேஷன் இண்டஸ்ட்ரி அது ஒரு லோக்கல் பாடி, நாங்கள் ஒரு சட்ட ரீதியாக ஒரு ஸ்டாட்யூட்டரி பாடி, நாங்கள் ஒரு அரசாங்கத்தோட ஒரு அம்சம், அதனால நாங்கள் ஒரு இண்டஸ்ட்ரி கிடையாது. திருப்பதியில் அங்கே இருக்கிற திருப்பதி தேவஸ்தானம் என்ன சொன்னாங்க, இது இஸ் a religious entity, நீங்கள் எப்படி இது ஒரு இண்டஸ்ட்ரின்னு சொல்ல முடியும்? இண்டஸ்ட்ரிக்கும் ரிலிஜனுக்கும் சம்பந்தமே கிடையாது, அதனால நாங்கள் ஒரு இண்டஸ்ட்ரியே கிடையாது అని சொல்லி இந்த பல விதமான வாதங்கள் வைக்கப்பட்டிருந்தது. So the whole issue then before the Supreme Court was, how do you then define what is an industry? Now who are the workers who can take recourse to remedies available under the Industrial Disputes Act? Now if you look at largely the Industrial Disputes Act, the purpose of Industrial Disputes Act is to maintain industrial harmony. It is not to to totally help labor or management, but it is actually from a larger social perspective. Because our economy olunga pono, ellarkume services olunga poi seranumna, there must be industrial harmony. Because our hospital la amirukra tholilali vela senjada and hospital olunga nadakum. Or club la amirukra ella workers olunga senjada and club olunga nadakum. So even though it might be offering various kinds of services, what is essentially required is cooperation between the employer and the employees. So that is the entire purpose of the Industrial Dispute Act, which is to maintain industrial harmony. Now if that is the fundamental purpose, if one goes strictly by the definition given in the Industrial Disputes Act and try to look at a commercial or a profit angle and say only it should be limited to businesses and trades, then vast sections of activity would be removed from the purview of the Industrial Disputes Act, thereby defeating the very purpose of the Act. So ultimately it will lead to industrial strife or lack of peace, lack of a harmonious functioning of various important institutions in the society. So in the perspective, I think the perspective becomes very important, because that also gives you a framework within which to understand provisions of law, which is very important, because ultimately the larger framework for understanding any law is the Constitution. So once you look at the constitutional goals, our preamble, the directive principles of state policy, which says that our state should work towards good living wages for workers. There should be worker participation in management. There are a lot of laudable goals in the directive principles of state policy. So how do you then harmonize all these things and interpret statutes so that it is in tune with the Constitution of India? So in this context, the Supreme Court has said that ultimately, in order to decide whether a particular establishment is an industry or not, all that is required is there systematic activity carried on in that establishment where there is cooperation between the employer and the employee, and that cooperation is for the purpose of either production, supply of goods or services, or distribution of goods and services, and was to satisfy human wants or wishes. So in the definition was read into the provisions of the definition of industry in the Bangalore Water Works case, and using this broad framework, the Supreme Court, I am now actually telescoping an entire history of about 2 to 3 decades, because the Bangalore Water Works case ultimately came only in the year 1978. But from the 1950s, 60s, 70s until the Bangalore Water Works case, which is a constitutional bench, settled the position of law, we have had this big confusion with workers going up and down. So though the Industrial Disputes Act is of the year 1947, most workers could actually benefit from the provisions after the Supreme Court in Bangalore Water Works case authoritatively pronounced what is an industry. Because otherwise, most often, the workers' entire lifetime went in arguing from the labor court or the industrial tribunal to the high court to the Supreme Court, first to establish whether his employer or place of employment is an industry or not. So அந்த ஒரு preliminary issueலயே அவனோட காலம் எல்லாம் போயிடுது. So finally I think you had large sections of workers who did not really get the benefit of the Industrial Disputes Act, though it was enacted in 1947 until 1978, when the Supreme Court laid down the law in the Bangalore Water Works case. So that, unfortunately now, in the year 2005, again the Supreme Court, we have come full circle, because the Supreme Court has now once again felt that the Bangalore Water Works case judgment may not be right, and they have now referred it to a larger bench for reconsideration of the ratio in Bangalore Water Works case. But till date, the larger bench has not been constituted. So as of today, Bangalore Water Works still holds the field, and the definition as given in the Bangalore Water Works case still holds good. Because just to complete the facts, because it could be very misleading, some textbooks in 1982, after the judgment in the Bangalore Water Works case, the Rajiv Gandhi government brought in an amendment to the Industrial Dispute incorporating the entire definition as given by in the Bangalore Water Works case and brought it into the statute, where they brought in the same thing. It should be systematic activity with cooperation between management and employer, where it is for the purpose of production of goods or services to satisfy human wants. They brought in this entire definition, and in the name of enforcing or giving effect to the Bangalore Water Works case, they then brought in a whole lot of exemptions, wherein they exempted hospitals, educational institutions, khadi and any domestic service. A whole lot of activities were exempted, whereby in effect you actually nullify the import of the Bangalore Water Works case. Fortunately, that judgment, because there was large scale opposition from the trade unions and many political parties, and so till date, though the amendment is of the year 1982, that amendment has not been notified. And now the entire issue is now pending consideration before a larger bench. But whatever that might be, and whatever might be the ultimate verdict of the bench when and where, if and when it is referred to a larger bench, as of today, the ratio in the Bangalore Water Works case still holds the field, and the definition of industry as stated in that judgment holds good. So now we have covered two aspects. One is worker, next is industry. Then the third aspect is, what is an industrial dispute? So industrial dispute means any difference between an employer and employees which is connected with employment, non-employment, or terms of employment or conditions of labor. So only it should be with regard to employment or non-employment, because in fact that was the argument which were put forth. Once a worker is dismissed, he is no longer an employee, and so he cannot come to the labor court, which defeats the very purpose of the act. So whether it is employment, non-employment, or terms of employment or conditions of service. So any dispute which is touching upon these aspects of an employer-employee relationship would be covered under the Industrial Disputes Act. For instance, supposing there is the supervisor there or the manager there has given some money to the worker, and there is a private money lending dispute, that will not become an industrial dispute. Supposing there is some personal animosity, that will not become an industrial dispute. So ultimately, it should be an issue of employment, non-employment, conditions of service, or terms of service. If it falls within this ambit, then it will become an industrial dispute. Now, having looked at these three broad, I would say the backbone of the framework of the Act, one other issue that will have to be borne in mind is that an industrial dispute by and large is always a collective dispute. So it should be espoused by a group of workers, ideally a trade union, but even there is provision for a group of workers. So then the issue came up, what about grievances of individual workers? Because if supposing a worker has lost his job, he has been dismissed from service or he has been retrenched, and the trade union on this under. Very often we find where individual workers don't want to join any union, they don't agree with any trade union, they are on their own. In such a situation, should an individual worker be left without a remedy merely because the existing trade unions do not want to espouse his cause? Because even an individual dispute becomes a collective dispute if it is espoused by a trade union or by a group of workers. So in such instances, to take care of extreme cases of non-employment, dismissal, retrenchment, an amendment was brought in to the Industrial Disputes Act, where the Act now says that wherever the issue involves dismissal or retrenchment or discharge of an individual person, it is a deemed industrial dispute. So not instances where an individual worker is aggrieved because he has not got promotion or he has not got an increment or he is being given a punishment of reversion. Now all this cannot be agitated by individual workers unless there is an espousal by the trade union. But the only exception is if it is a matter relating to dismissal, that is loss of employment. See, because loss of employment being an extreme punishment, the legislature has made an exception to the general and the broader concept of collective dispute, where only if a union or a group of workers espouse a cause, you can actually access the machinery under the Industrial Disputes Act in order to ensure that these individual workers are not left in the lurch with no forum to go before. They have brought in this section 2 capital A, where individual disputes of dismissal are all deemed industrial disputes. So this gives you the broad framework. First, the person should be a worker, he or she should be employed in an industry, it should be an industrial dispute, by and large only collective disputes, but in the event of termination or loss of employment, even an individual dispute becomes a deemed industrial dispute. So this is the first definition part of the Industrial Disputes Act. So then how do you access this machinery? So நீங்க முதல்ல ஒரு client வந்த உடனே இதெல்லாம் முதல்ல ascertain பண்ணிடுவீங்க. சரி, you are a worker, நீ வேலை பண்றது ஒரு industry, நீ உங்ககிட்ட இருக்கிற dispute is an industrial dispute. So once you ascertain these three facts, then what next? So the Industrial Disputes Act, as I told you, the purpose of the act is to ensure industrial harmony. So எடுத்த உடனே ஒரு litigation modeல போக கூடாது. The first attempt should be to arrive at settlement, ஒரு conciliation. யாராவது ரெண்டு பேர் உட்கார்ந்துட்டு பேசலாமே, பேசி முடிவு பண்ணலாமே ன்னு சொல்லி, that is the whole approach. How in family court there is now mandatory conciliation. Similarly, in 1947 itself, in labor disputes, the entire approach was, let us first try to bring a settlement between the workers and the employer, because all said and done they have to work together. So litigation can estrange and bring in more tension. So the first attempt is to conciliate. So the act provides for conciliation officers who are our labor officers. இப்போ நம்ம சென்னை பொறுத்த வரைக்கும் குரலகத்தில் உட்கார்ந்துட்டு இருக்காங்க. Labor officers, jurisdictional wise you have labor officers. So முதல்ல, whether it is an industrial dispute or whether it is an individual dispute, the first step, we as lawyers, and I mean even trade unions can do it, doesn't require a lawyer. You can first write up your petition. It can be in there is no legal format for it. It can be just like a letter where you make a representation to the conciliation officer explaining the facts and requesting the conciliation officer, please intervene in my behalf. Now you must keep in mind that the conciliation officer really does not have much powers. He can only persuade. His findings are not binding on anybody. He doesn't give any findings. He only makes an attempt to bring in a settlement between the parties. And he belongs to the labor department. So the idea is that if a neutral person who belongs to the government and who is trained in these matters, if that person sits as a middle person and tries to bring these two parties to the table and try to arrive at a settlement, that is seen as a best settlement, which is actually has the highest sanctity. Even the Supreme Court has said that settlements should be given their due and it should be duly given weight. So that is the first attempt in respect of resolving a conflict. In fact, I would go even a step further. If there is a dispute, if you are by any chance advising either a management or the workers, today in days of high unemployment, where getting re-employment might be a tall task, and the vulnerability of workers who are coming from very poor backgrounds, because losing an employment would really mean economic distress to the family. I think as lawyers we have to be very responsible in giving them advice, because we should not do anything to precipitate the conflict or to create more animosity between these two parties, the employer and the employee, because ultimately they have to live together, they have to work together. Just as a wife and husband, you try to bring in some conciliation, because the idea is that you try to preserve the institution in the hope that they would live in harmony. A similar approach here, keeping the larger society in view, because industrial harmony is good for the society at large. Whether you are advising the management or the workers, I think the first attempt should be, can you call the parties and try to conciliate? Because the Industrial Disputes Act also provides for that, where just the workers, whether individual or trade unions, along with the management, without a third party, can actually sit together, put forth, because I know that many employers are allergic to trade unions. Somewhere down the line we have all developed this mental and emotional barrier that somehow trade unions are bad. And the moment a union is formed in any industry, the employer has a sense of panic. The first attempt is, how do we finish off this trade union? How do we ensure that this trade union nipped in the bud? Or shall we put up a rival management trade union so that we have one set of workers who are loyal to us, so that we use them to counter union. Now this is the thinking and the approach which is prevalent today by and large. But I think one should see a trade union as in fact an advantage, because if there are thousands of workers, it's easier to negotiate with the representatives than to go and negotiate with 1,000 workers. So, while this is not to say whatever may be the criticism of how the trade unions have been or what the managements are, how managements function, I think one again needs to go back to the fundamentals as to what is the purpose of Industrial Disputes Act, and if industrial harmony is the basic reason for the Industrial Disputes Act, I think we as professionals who are advising either the management or the labor should first try to attempt at trying to find a solution. And if the parties, without any third party intervention, which is the conciliation officer of the labor department, if they come together and enter into a settlement, this is a settlement which is arrived at under section 18. In normal parlance we refer to it as the 18-1 settlement. 18-1 settlement is a settlement which is arrived at between the workers and the management without a third party conciliation or mediating or supervising the terms. So there is nobody to actually check if the terms of settlement are fair, because such settlements are binding only on the parties to the settlement. So I will just explain the distinction to you. A settlement which is arrived at under section 18(1) just between the management and the workers is only binding on the trade union or the set of workers in the settlement. It is not binding on the other. Maybe there are several trade unions. So out of 4 trade unions, if only one trade union signs a settlement, then it is only binding the members of that one trade union and not the other trade unions. No management would want a situation like that with one set of terms of conditions with one set of employees and a different set with the other set of employees, and that doesn't really help with industrial harmony. But law contemplates a situation where this kind of a settlement is possible, and there have been situations where even managements have entered into individual settlements and ensured that individual workers settle the dispute, so that of course there is a larger political way of whether it amounts to weakening the trade union movement, etc. is a larger debate. The next is, now supposing an 18(1) settlement does not work and the management and the unions are unable to come to terms. So the next step would be the conciliation officer, where in the course of conciliation both the parties can again arrive at a settlement. So this is a 12(3) settlement, a settlement arrived under section 12(3) subclause 3 of the Industrial Disputes Act. So this settlement, the difference between the 18(1) and the 12(3) is that the 12(3) settlement, because it is arrived at in the presence and also with the participation of the labor officer, who is supposed to be playing a neutral role, who is also looking at the terms of the settlement to ensure that the terms are not one-sided, that the terms are. So since you have a third party who is like an umpire, who is looking to see that no one side is actually getting away, and it is a fair settlement. Such a settlement which is arrived at in the course of conciliation is binding not only on the unions who are party to the settlement, but to all other workers, which means it's binding on the entire industry. And hence the onus on and the responsibility on the unions which are negotiating and on the labor officer who is conciliating is very crucial and should be taken very seriously, because it binds all other workers who may not be party to this settlement. So this is what the Act contemplates. Now you move to the next stage. What if this settlement doesn't come through? Very often, very rigid stance, nobody wants to give in. Unfortunately, sometimes there could be egos on both sides. So in fact, I think as professionals, since we do not look at egos, we look at practicalities. it would do well to advise both the management and the workers, don't stand on egos, don't stand on prestige, because the lives and the welfare of a whole lot of workers is dependent on settlement, on the management and the workers working together. So in such a context, I think the approach should be to ensure, I am not saying that we should agree for unfair settlements, but yes, one should approach a conciliatory, have a conciliatory approach, and as far as possible avoid litigation, arrive at a settlement. But it's not always that there is always such a happy ending. So then what does the labor officer do? So labor officer ku settlement varlena oru power kadayadu. He cannot compel parties, he cannot summon them. Sila time illa management notice kuduthalum varave matanga. Illa some clerk to mark attendance. So it is that nobody responsible at a managerial level who has the power and the authority to take decisions is ever sent. So in such situations, conciliation is bound to fail. So then once conciliation fails, the conciliation officer prepares what is called the failure report, conciliation failure report. So in the failure report is the first step to access the machinery under the, that is the legal machinery under the Industrial Disputes Act. Now once the failure report is in hand, as far as individual workers are concerned, the individual worker who is facing non-employment, dismissal, retrenchment can directly file a petition within 45 days to in the labor court. So that is easy, because earlier you had to go through a reference process which I will explain, but as far as individual workers are concerned, they can directly go to the labor court. The next step is that labor officer forwards this failure report to the labor commissioner, because the labor commissioner is the head of the department. The labor commissioner then forwards it to the secretariat, the secretary department of labor, which is to the government, the state government, and the state government will then have to refer the dispute for adjudication to, depending upon the subject matter, because you have schedule 2 and schedule 3 to the act. Schedule 2 lists out the subject matters that can go before labor court, schedule 3 the subject matter which can go before the industrial tribunal. So accordingly, the government under section 10 of the Industrial Disputes Act refers the matter for the adjudication. Of course, what I am not elaborating, but I must tell you is that the act also provides for arbitration, but it's very few who actually access the arbitration under the act. It is generally adjudication. The adjudication process is initiated by a reference from the government. Now whether it should be the state government or the central government, again the act defines which is a appropriate government, and only central government establishments or public sector which are under the control of the central government, the appropriate government is the central government, in which case the conciliation is done by the central government labor officer sitting at Shastri Bhavan, and the reference is also done by the central government and not by the state government. But by and large, all other establishments within the state would come under the state government, and the appropriate government will be the state government. I am not going into details about which is an appropriate government, because there are a whole lot of case laws and it's settled position now. But because dispute does arise very often, because reference is not valid, because the reference is not by an appropriate government, is one set of litigation which comes time and again. So once you go, the matter is sent to the government has to refer it. Now let me tell you that from 1947 to 1989, getting a matter referred for adjudication has been an uphill task for most workers in the country, because invariably managements do have their own clout or influence or whatever you might say, more money power, political power, access to power, whatever might be the reality. The fact remains that governments tend to favor the employer, and very often you had governments rejecting or refusing to refer the disputes for adjudication. Now, though the enactment is of the year 1947, level, the workers had to struggle to even access the machinery under the Act. So first 2 decades or 3 decades after the enactment, the whole issue of whether you are a worker, whether it is an industry, whether it is an industrial dispute. So you had until the Bangalore Water Works case, extensive litigation on this count, denied access to the labor machinery, to the adjudication machinery under the Act to most of the workers and the trade unions in the country. The next hurdle was with regard to the reference part. So governments invariably, இதெல்லாம் தேவையில்லை, இல்லைனா இது தொழில் தகராறே கிடையாது, இல்லைனா மேனேஜ்மெண்ட் உங்களுக்கு சப்போசிங் இட்ஸ் டிமாண்ட் ஃபார் போனஸ், இல்லை மேனேஜ்மெண்ட்க்கு இந்த வருஷம் ரொம்ப நஷ்டம் வந்துருச்சு அதனால போனஸே தேவையில்லை, கிராச்சுவிட்டி அவன் கொடுத்த கிராச்சுவிட்டி போகிறோம் நீங்கள் இதுக்கு மேலே தேவையில்லை, இல்லைனா ஹாலிடேஸ் ஓட கண்டிஷன்ஸ் சர்வீஸ் கண்டிஷன்ஸ் மாற்றிட்டாங்க, இல்லை இந்த சர்வீஸ் கண்டிஷன்ஸ் நல்ல கண்டிஷன்ஸ் தான் அதனால இதெல்லாம் ஒரு இண்டஸ்ட்ரியல் டிஸ்பியூட்டே கிடையாது, இதுக்கு ஒரு ரெஃபரன்ஸே தேவையில்லை, நீங்கள் கோர்ட்டுக்கு போக தேவையில்லைன்னு சொல்லி தொடர்ந்து ரெஃபரன்ஸ் ரெஃப்யூஸ் பண்ண ஒரு வரலாறு தான் இருக்கு. Finally, after extensive litigation, this was again everything. Of course, see, the employers do have the luxury of litigating up to the Supreme Court at every level. So first tier, second tier, third tier. So everything had to be finally settled by the Supreme Court. Then finally the Supreme Court said, when the government is exercising powers under section 10 of the Industrial Disputes Act, it is only an administrative power. It is not a quasi-judicial power. So they cannot adjudicate. They cannot discuss on the merits of the case. They cannot say what is good, what is bad, what are the merits of the case, whether the workers, really the demand is genuine or not. All this is besides the point. And the only business of the government is to refer the dispute, because it is more like a little more than a post office, because there is a slight discretion which is given that in the event of the dispute being very stale, supposing after 30 years somebody is litigating, then in those very rare circumstances the government can say no, this is too stale a dispute, and they may refuse to refer. But the rule is today the government must refer a dispute for adjudication, and the government cannot exercise any kind of discretion there at that point in time to deny a reference. So there is an entire line of case law on refusal to refer, and today the law has been settled. So first, once you come, that is when you finally, after this entire process, you come to the labor court or the industrial tribunal. Once you go before the industrial tribunal, then I think for workers, if those of us who are appearing for the workers, very often evidence becomes a problem, because we know, how do you prove employment? You have an appointment order. How do you prove whether you have worked or not? You have an attendance register. How do you ensure what is the kind of wages? There is a wage register. But who has all these things? Invariably all the records are with the management, and by and large, especially with the manual, skilled, unskilled workers, you will find, or even at the clerical level, most managements don't even issue a appointment order. It's all oral, especially in the private industry, and even in the larger industries, in the informal sector, because for every set of permanent employees that are there in any industry, you have a large section of workers who are in the informal, who are casual labor, in the name of casual labor, temporary workers, badlis, muster roll, various kinds of names are used. But they are all in the informal sector where they may not be in the permanent roles of the industry. So very often a worker never has documentation to prove his very employment, which is the first step. No labor court or industrial tribunal can adjudicate without evidence. And so the responsibility of a labor lawyer who is representing the workers is that much more, because you have to take care to at least start, you need to prompt the worker at every level to say, any documentation, do you have any documentation to show that you are a worker? Some identity card, some letter, some expenses which might have been paid, anything at all which proves an ESI card or an EPF card, anything which will show some employer-employee relationship. If all else fails, I think the only option left very often is oral evidence. So don't undermine the importance of oral evidence, because oral evidence is also evidence. While documentary evidence is definitely good if we have it, but as is the wont in most cases of laborers, many of them may not have appointment orders, may not have any documentation, in which case you can ask the worker to get into the box and give evidence. And there have been, I think most cases, I mean, the judges are trained to appreciate that evidence and assess fairly well whether the worker is telling the truth or not. And on the basis of the oral evidence also, the courts can come to the conclusion that a particular worker is been in employment with the employer. So I think evidence is, as far as when you are representing workers, becomes very important. And pleadings, I think one has to take a lot of care to ensure that you plead everything in your, because there is a tendency generally to be very brief when we are writing a claim petition. You don't give any details. What is the nature of work? See, it is important to describe in detail, because the first thing, the first line of preliminary issues that a management would raise is, so and so is not a worker, so and so, or we are not an industry. These are all standard, you can expect preliminary issues which every management would raise. So it is important that your pleadings anticipate these kind of objections or counters, and inbuilt into your pleadings all the facts which are required to show that one, the worker is doing either manual, skilled, semi-skilled, operational, clerical. Describe the work at length, because very often, as I said, the designations are misleading. You might just say the so and so is working as a assistant manager. So immediately the defense of the management will be, manager is not a worker. And then you are also at a loss because you are also caught by the designation. Ensure that your pleadings give in detail that no, as soon as he goes in the morning, he has to make entries in all these registers, or he has to operate a particular machine, or this is the kind of record work that he maintains. Now, whatever might be the nature of the work will have to be given in great description. Also describe the industry. What is the nature of the activity? See, very often another aspect which can be very misleading is the labeling of workers as apprentices. Because very often apprentice, by our general understanding, is a training, is a person who is in training, who is under training. So an apprentice by definition, of course not under the Industrial Disputes Act, but generally the tendency is an apprentice is not a worker. So I think it is important to also inbuild into your pleadings that though you have been named as an apprentice, the worker, I mean all this, if it is the truth, I am not saying fudge facts, please don't, because anytime you fudge facts, they will bound to get exposed. So I think ethics, I think Mr. Justice Chandru spoke about, I don't know how many of you heard his lecture about professional ethics. I think that holds good across the board, whichever branch of law, that while yes, we have a duty to protect our clients, whether it is the workers or the managements, bottom line is that you don't tell lies in court, you stick to facts. I mean, we can't improve the facts of a client, but what we can do is that project the facts in a manner so that you can get relief to the client. You must be able to convince the judge, putting the larger context of the facts and the framework in such a way that you are able to persuade the judge that the client is entitled to relief. But for heaven's sake, don't fudge facts, or don't try to say something which is non-existent, or don't try to fabricate documents. If you don't have an appointment order, don't type up an appointment order, or don't advise the clients to say go somewhere and type up an appointment order and come. Don't do things like that. But at the same time, spend a lot of time with the worker to ensure, to jog his memory slowly, to ensure that the maximum amount of facts are garnered before you actually prepare your claim petition. And once that is done, you put all the facts inbuilt into it, and then be prepared to lead the evidence in a systematic way, because very often workers' cases are lost because of us lawyers, because we fail to bring in, because workers are depending on us. They may not know what to bring in before the courts. So documents are not marked, relevant documents are not called for. So because if you don't have, you can file interim applications, IAs, summoning documents, because many of them are statutory documents, which under the various statutes, whether it is the Minimum Wages Act, or the Standing Orders Act, or the Shops and Establishments Act, or the Payment of Wages Act, every act has a whole lot of registers which are mandatorily to be maintained by employers. And you have a right to summon those documents, And if you file an interim application calling for those documents, if the management fails to bring those documents, there is a presumption in your favor. So the Evidence Act 114 will come into play, and you can always take advantage that the management has not brought in those documents only because those documents are in your favor and against the management. So that presumption would work in the favor of the workers. But please take the pains to do all that. Go through all the other existing labor legislations to first understand what are the various documentation that is likely to be available with the management which you can summon. And painstaking, you can put it down. And also there is a time period, mandatory statutory time period during which the records have to be preserved. So keep in mind all that, look at the other legislations and call for those records. And lead the evidence, mark the documents that you can. And as I said, oral evidence, you can get oral evidence of co-employees, you can get oral evidence of ex-workers. So you don't have any embargo as to whom you can bring in to lead evidence to establish your case. And once the case, of course the management is also entitled to lead their own evidence, and the award is passed. Once an award is passed, the award is binding and for a period of 1 year, and thereafter, of course, if the dispute continues, the entire cycle starts all over again. You can terminate the award, but it's binding for a year. Now, the next, as practitioners, I think what we will need to know is that apart from the Industrial Disputes Act, one other enactment which might be useful for giving relief is the Shops and Establishment Act. Because many of the salespersons we see in all the various shops, people who are employed, they may not be coming within the definition of an industry, but they would fall within the definition of an establishment under the Shops and Establishments Act. In which case, Section 41 of the Shops Act becomes very important, because under Section 41 it is just one section, it's a small enactment, one section, and I think since we are in Chennai and since all the practitioners here know Mr. NGR Prasad, you must have either seen him or heard of him. He is today one of the leading practitioners in labor law and a very senior person who is 80 but very active and young at heart. His office is called as Rao and Reddy, and it's a partnership firm. And Mr. V.G. Rao, who is one of the founding members of that office, it is an office which was formed even prior to independence, who was a barrister and who had come back here and started this office, Mr. V.G. Rao and A. Ramchandran. The Shops and Establishment Act, I am just giving you this piece of history. Shops and Establishment Act was first conceived and drafted by Mr. V.G. Rao. And in fact, the Tamil Nadu enactment is the first enactment which has become the model for all other similar enactments in other states in the country. So the Tamil Nadu Shops and Establishment Act, we can all feel proud, has come from Chennai and from an office which is known to all of us. So the Shops and Establishment Act, Section 41, is again a very useful section for workers to access, because if you do not come within the definition of industry, for the shops and establishment, under Section 41, termination by an employer should always be only for sufficient cause. It's just that one word, sufficient cause. So, and I think in that one brilliant word, Mr. V.G. Rao has brought in an entire protection to a large number of employees who are otherwise not covered by any law. And so today, if an employer terminates the services of an employee in any shops and establishment, all that you have to do is that there is no sufficient cause to terminate you. So just poor performance. So at least you have an authority who can evaluate and be the umpire to adjudicate whether there is sufficient cause or not to throw out an employee. So this enactment is again a very useful and a very helpful enactment, which I think anybody who is serious about labor practice should read it. So these two enactments by and large give you the framework for access to the various, especially in cases of termination. So once you get an award either under the Industrial Disputes Act or under the Shops and Establishment Act, by and large you can be pretty sure that managements will file a writ petition against the awards, because there is no appeal within the statute, because the statute says that is final, but managements do tend to file writ petitions under Article 226 in the High Court. So we had another situation where workers succeed. So after establishing you're a worker, after establishing you're an industry, you're working in an industry, after establishing that it is an industrial dispute, after succeeding to get a reference from the government, after this long battle, if you finally get an award in your favor from the labor court or the industrial tribunal, there is a challenge in the High Court and the whole thing gets stayed. So the workers' relief is still years away. So you had workers who succeeded at every level but still not able to get the benefit of the awards and still facing the same economic hardship of being without employment. So the Parliament came up with some kind of a via media solution where they introduced in 1982 Section 17 capital B in the Industrial Disputes Act, where the statute says that if there is an award in favor of a worker granting reinstatement, this I am talking in the context of individual disputes of non-employment, dismissal, discharge or retrenchment. If there is an award granting you reinstatement and if the management files a writ petition challenging that award, then as a lawyer representing the workers, you can move an application under a miscellaneous petition, call it an MP or a WMP. The nomenclature has been going around in cycles in our High Court. It was WMP, MP, and now we are back to WMP. So you can move a WMP requesting the court to pay you the last drawn wages of the worker under Section 17 capital B of the Industrial Disputes Act. So it is important to plead even at the labor court level what your wages were at the time of your termination, and as far as possible also have your wage slip, the last wage slip. If workers have the wage slip. If the workers don't have the wage slip, at least there is a pleading in your pleadings before the labor court, and at least one judicial authority, a body adjudicating in your favor, recognizing that this is the last drawn wages drawn by you. You can use that and you can file a petition saying that this section provides for payment of full wages, the last drawn full wages during the pendency of the writ petition. The only condition is that the worker will have to file an affidavit to say that he or she is not gainfully employed anywhere else. So please remember to use those words, because your petition can get dismissed if this pleading is not there, that the worker is not gainful. Again, it's not uncommon for managements to even challenge this, because there have been situations where management try to find out if the worker is employed elsewhere, try to get those documents to show the court, no, so and so is employed. In fact, when I was a law student and I was interning with some labor lawyers, we really even had a case where it's very strange, that's why I never could forget it, where the management actually filed a counter saying that so and so is making money begging on the roads and hence is gainfully employed and so is not entitled to last drawn wages. So, that is the extent to which managements can contest cases. So, be careful about how you put your pleadings. And also advise a worker that, sometimes you may eke out a livelihood by doing some small odd jobs. That doesn't mean that a worker, after all, persons have to live. They have to, put body and soul together. They need to feed their families. So, you just put in that word. And I don't think today's employment condition is not as if the worker is going to get any employment of the same standing that he lost. And then once you find that, you can get a order. This by and large these days you get it automatically, though there are still some judges who deny you this relief, though the statute says 17B should be paid. And sometimes there is also this, if they feel that a worker is too bad and they don't want to give you relief, the judges still say, no, I will hear the main case, and will refuse to pass orders in the MP. So those situations still happen even now. But by and large, judges do grant you 17B. There have also been instances where the managements have challenged in writ appeals orders of 17B. And so I'm saying the access to courts for workers is a long journey. So this is as far as section 17B is concerned. And finally, if you do succeed in the High Court and if the management doesn't take it up to Supreme Court, then you might get your relief. But yeah, so this is the broad scheme of the Act as far as the adjudication process is concerned. I think two other, what is the time frame that we have? To complete the provisions of the Industrial Disputes Act, because again these are very important, please do look at chapter 5A and 5B of the Industrial Disputes Act. These chapters are very important because the first part of the first 4 chapters explains to you the adjudication machinery, the definition clauses, then you have the whole affiliation process, the reference, the adjudication, the awards, then you have what is a strike, what is a process for issuing notice for strike, all those provisions are there, what is an illegal strike, and those provisions are there. I am not going into the larger issues of strikes and legal, illegal, because that could be very fact specific. But again, from a general practitioner's point of view, something which you may need to know is the provisions with regard to retrenchment and retrenchment compensation. Because you need to understand what is retrenchment. So the definition of retrenchment is given in section 200 of the Industrial Disputes Act. And this again, like, you can be sure that every single provision of this act has come up for interpretation. And 200 says that retrenchment means termination by the employer for any reason whatsoever. That is the language used. So retrenchment is termination for any reason whatsoever. See, generally in the normal understanding of retrenchment, a person gets retrenched if a worker is surplus. Supposing you have 20 workers, but then management requires only 10 workers, there is no work for 10 other workers. You retrench those workers. So it is not a disciplinary action, it is not a dismissal in that sense of the term. The workers are rendered surplus and so you retrench them. But the definition under the Act says it is termination for any reason whatsoever. And this clause came up for consideration by the Supreme Court in the very famous Sundaramani case, which again is a case which went up from our High Court, argued by Mr. N.G.R. Prasad and A. Ramchandran from Rao and Reddy office. Sundarammal is a celebrated case for the working class today, Sundaramani. And in Sundaramani's case, the Supreme Court said that the definition of retrenchment cannot be confined to situations of surplus labor, because the definition, the statute very clearly says it is termination for any reason whatsoever, and the words any reason whatsoever should be given its full amplitude and be given its full meaning. So any termination of any kind, which is other than termination by way of disciplinary action, would fall under the definition of retrenchment. Now why does it become important? Now before I go to the other provisions of retrenchment, what would be important is, please note the subclause BB, 200BB. BB has been introduced in 1984 because 200BB, because of this Sundaramani's case, the legislature brought in this subclause to say that if the termination is on account of the expiry of the contract itself, then it will not amount to retrenchment. Supposing you have hired a worker for 3 months or for 1 year, your appointment order itself says, I am engaging you, the appointment order says you are going to be engaged for a period of 1 year, after which your employment ceases. So the question is, does it amount to retrenchment or not? Because under 200BB, which is an amendment brought in 1984, it says that if the contract itself comes to an end, then it is not a retrenchment. So then it becomes a very easy exit point for most managements, because every appointment letter will give you a end point. It will tell you that your termination, your employment is for 1 year, 3 years, or whatever is the period. So this clause again has come up for interpretation, and the Supreme Court and various judgments of our High Court, they have said that you cannot, like even in our Chennai Corporation, you have most of our conservancy workers, the people who keep our streets clean and who clean our drainages and all our enter our manholes, they are all under these 89 days employment, and this is by the Chennai Corporation, which is our local body. At the end of 89 days, they terminate the services, and then after 2 days break, they re-employ the workers. Or what they do is, one set of workers for 89 days, another set of workers for another 89 days, then you come back to the first set of workers, so you also have this rotational merry-go-round which happens. So all kinds of practices are indulged in to ensure that the benefits of the labor welfare legislations don't ever reach the workers. So now these are all very practical issues that labor lawyers would face if you are representing the workers, or even if you are advising the management, because you need to know these things. So the Supreme Court has said that you cannot create artificial breaks in employment. So which means actually the work continues, you continue the workers also, but you just create these artificial breaks. So you cannot bring in these artificial breaks. You have the American Express case, and there's a whole lot of case laws for that. Then the other issues are the set of judgments interpreting 200BB, where they say that if the employment and the nature of work itself is permanent, you cannot have an employment stipulating that it is only for a period. Supposing you are running an industry where operating a particular machine is actually the main backbone of that industry. If you don't operate that machine, the industry will come to a halt. You can't employ workers in that to operate that machinery for 90 days or 1 year and say that the contract of employment has come to an end, because the nature of work done by the worker is permanent. The work continues. You are only changing the worker. So if the work is permanent in nature, then 200BB will not apply. So this clause will have to be given a meaningful and a purposive interpretation to ensure that it does not, this one single clause will not nullify the entire act. Because if this were only interpreted by the letter, then every employer will issue appointment letters bringing in a inbuilt period of service. So the rest of the act then becomes redundant. So one cannot bring in that kind of redundancy to a legislation, and so Supreme Courts have interpreted in various judgments that 200BB contemplates a situation where the work itself, supposing it is metro, for instance metro project is happening, you hire workers there, the metro work project is over, then the employment itself comes to an end, then in those cases 200BB will come, then it is not a retrenchment. So if you have been hired for a particular seasonal work, or for a particular project where the nature of the project is such that it is very time bound, and at the end of the period stipulated the work itself ceases to exist, then in those cases section 200BB will come into operation, and termination in such cases will not amount to retrenchment. But otherwise, except in such situations, all other terminations other than dismissal, voluntary retirement or superannuation, those are of course where your employment comes to an end in the natural course. Apart from these exceptions, any other termination whatsoever would amount to retrenchment. Now why is this word retrenchment and knowing what retrenchment is important? Because the Act gives in certain safeguards to the workers and places some mandatory conditions on the management before they take recourse to retrenchment. Now in respect of industrial establishments, see there is a difference between industry and industrial establishments, a marginal difference, but I will not go into that into detail. By and large it would overlap, but what you need to know is that in respect of establishment which engage more than 100 workers, if an employer wants to retrench workers, they will need to get prior permission from the government, and only if you get such prior permission you can retrench the workers. So that is section 25N of the Industrial Disputes Act. Then what are the section 25F is another clause which is very important for all individual workers who are retrenched, because 25F prescribes two conditions precedent. Please take note of the word precedent, because it should precede the act of retrenchment. So before an employer retrenches any worker, there are two mandatory conditions that an employer has to satisfy before effecting retrenchment. One is you have to give the worker 1 month's notice or notice pay. So you will have to give the 1 month mandatory notice. Then you will also have to pay the workers retrenchment compensation, which is calculated on the basis of 15 days wages for every year of service. So these two conditions precedent will have to be complied with before you retrench a worker. And what if you violate it? I mean, very often the tendency will be paathukalam, நம்ம பண்றது பண்ணிடலாம், அப்புறமா கோர்ட்டுக்கு போனா அங்க பாத்துக்கலாம். That will be a general attitude. There is a tendency to advise the workers, பண்ணுங்க சார் அப்புறமா பாத்துக்கலாம். Now what is the implication of retrenching a worker without following these two conditions? The Supreme Court said that if you do not follow these two conditions, then the retrenchment is void ab initio, and hence the worker is entitled to reinstatement with back wages. Of course, I am not going into there have been a whole line of judgments about back wages, no work, no pay, how much back wages. I will not go into those line of decisions, but this is a broad principle where if you do not follow the conditions stipulated in section 25F, then any retrenchment made in violation of 25F and 25N, where if it is more than 100 workers, you will need to get prior permission from the government. If these two provisions are violated, then the retrenchment is void ab initio. Now the next issue comes. Supposing you are advising a management. The management says that I want to send out 10 workers because I don't have work for them. Could be a very legitimate, even assuming that it is a very labor friendly, very good management which has the interests of their workforce at heart. And if they come to you for advice, please tell me how I should go about it. You must tell the management that apart from fulfilling the conditions under section 25F, which is notice and retrenchment compensation, the act also, you have to look at section 25G and H of the Industrial Disputes Act. Now what does 25G say? 25G stipulates the principle of last come first go. So which means that if there are 30 workers in a factory and if the management needs the services of only 20 workers and they want to send home 10 workers, they can't pick and choose. They can't say, oh, this fellow is a troublemaker, let us use this opportunity to send them out. Or, oh, these workers, these set of seniors are now too old, so let us get rid of the older workers so that we have a younger workforce. That cannot be the approach. The act itself says that the person who has come last should go first. So the principle of last come first go is what section 25G contemplates. And so the employer has to prepare a seniority list, and then the bottommost 10 workers alone should be sent home. And you cannot pick and choose or send senior workers and retain the junior workers. So this is what the act contemplates. Now supposing an employer has retrenched the workers. So, I mean, you are carrying on a manufacturing process. Suddenly this particular year, your orders have come down. So instead of operating 5 machines, you are operating only 4 machines. So 10 people have become surplus, and you have followed the law and you have retrenched them. By giving them notice, you have given them retrenchment compensation. You have also followed the principle of last come first go. Then next year your orders have improved. Now you want to operate the other machinery which has been lying, and you want to now hire workers again. So now what does the Industrial Disputes Act provide? Section 25H of the Industrial Disputes Act says that when an employer retrenches workers, at least for a period of 2 years, you need to maintain that list of workers, and that in the rules it is provided. But the Act says that you must then first offer re-employment to the workers who have been retrenched under Section 25H. So individual letters of offer should go to these workers and tell them, look here, now I have work for you, so if you want to come back for employment, please do. Once you make that offer, if the worker comes, you have to provide him employment. If the worker does not turn up, then you are of course open to recruit fresh hands. So this is the protection and the scheme which has been put in place in the Industrial Disputes Act, because as I said, ultimately the purpose of Industrial Dispute Act is one, industrial harmony, and also taking into account the larger social good, because here we are dealing with people. These are not commercial disputes. You are dealing with people, livelihoods, lives, families. So that is why the legislature thought it fit that you need to build in these safety nets at every level, so that workers are not arbitrarily thrown out of employment, because for every worker that is thrown out of employment, you must remember that there is a family that they are supporting. You have children who are going to school. You have old parents who may need to be given medical support. So there is a social component as far as labor disputes are concerned, and it is keeping in mind this social component that this security nets have been placed at every level, so when you throw out a worker, you give them retrenchment compensation, so that at least they'll have some money to go by until they find another employment. Then if there are employment opportunities in the same industry, that worker has the opportunity of coming back again. So I think one other thing which you will need to keep in mind is that the retrenchment compensation, the liability to pay up compensation will arise only if the worker has completed 240 days in 12 calendar months. In any 12 calendar months, it need not be any financial year, it need not be any calendar year, it is any 12 consecutive months. So it can be December to December, June to June, anything, August to August, but any 12 calendar months, if the worker has put in 240 days, then section 25B of the Act defines what is continuous employment. So the worker is said to be in continuous employment, and hence once you complete 240 days in 12 calendar months, then the provisions of section 25F dealing with retrenchment compensation and notice kicks in, and the worker has to be given these benefits. But as far as 25G and H is concerned, this 240 days does not come in, because the 240 days is required only to decide on the compensation part and the notice part. But as far as last come first go principle and the principle of re-employment is concerned, in the Central Bank of India case, the Supreme Court said that you need not necessarily mean that because you have not completed 240 days, the worker is not entitled to the benefit of the provisions of section 25H of the Industrial Disputes Act. So this, I think, okay, one other important part which you may need to know as practitioners is 25O, which deals with closure of industry. Now, closure becomes again a very important aspect, because very often these days we are confronted with scenarios where employers shut shop and disappear. I think more so with globalization, because now we have employers with global presence, so it is no longer shifting locally, they shift nations. So if India is no longer lucrative, you can go to Philippines or Malaysia or Korea or whatever. So the Act provides for a procedure. Now the argument, generally it might seem to you that I started an industry, now I want to shut it down, it is my industry, so what is wrong with it? So that is the general layperson's perception. So it is my industry and I want to shut it. So who are you to tell me to run the industry? You cannot force me to run an industry or to run a business. Then why does the Act say that it is not open for you to shut shop whenever you want? Again, you will have to go back to the fundamentals of industrial law, because industrial law is not just commerce, it is not just money, you are dealing with people and lives. So there is a social welfare angle to all industrial disputes. So while the Supreme Court said that while it is the right and the prerogative of any individual to decide whether you want to start an industry or not. So nobody can tell you, come here, you start this industry now. No government can compel you to start a business or to start a trade or start an industry. It is up to you. If you want to start an industry, you will start it. If you don't want to do it, you need not do it. But once you start an industry, then it is no longer just you who is involved. Until you start, only you are involved. Only the management is involved. But once you start, then the third party rights follow. Since the third party rights follow, then you can't, your exit option can never be unilateral. See, apart from the commercial angle of your suppliers need to be paid, all the other debts, your banks, apart from all that, you also have the issue of workers. So the Industrial Disputes Act says under section 25O that if an industry wants to close, whether a permanent closure of either the full industry or a part of the industry, because section 2cc, which defines closure, contemplates even a partial closure. So you might be shutting down a section of the industry. You need not close down the entire industry. You might shut down one wing of the industry. Even in such situations, you need to make an application to the government and seek their permission to close the industry, and when such an application for closure or for retrenchment in respect of where 25N will apply, the workers, the trade unions have a right to be heard. You can also say, because most often, there is a Reserve Bank of India report. I'm sure the general feeling is that trade unions are troublemakers and most mandates are lost on account of strikes. But more industries are shut down on account of mismanagement. That is what the Reserve Bank of India report says. And so mismanagement cannot be a reason for shutting down an industry and penalize the workers who are dependent on it. So when you want to close down an industry, you make an application, the workers are entitled to be heard, and the workers can oppose the closure and tell the Labour Office, the Labour Commissioner, that you should not permit the industry to close down. And if an industry closes down or retrenches workers in violation of 25N, or if its closure in violation of section 25O, then the workers are entitled to wages for that entire period of closure until the permission is obtained. And any order of closure can also be taken up, an industrial dispute can be raised. That means you can start supposing permission for closure is given. The workers have a right to raise an industrial dispute, and ultimately the industrial tribunals can decide whether the order granting closure or refusing closure is legally valid or not. Because the Act also stipulates what are the circumstances under which the closure can be granted, and if those circumstances are not fulfilled, then closure can be denied. But having told you what the law is, it does really seem to be a paradise for workers, because at every level there is protection. But what happens in reality? Managements just shut shop, period. They are not bothered about the law. So that's what happens, whether it is a public sector or whether it is a private sector. One, of course, is they float a voluntary retirement scheme and send the entire set of workers on voluntary retirement scheme. So when the closure application is made, there are no workers to oppose the closure. That is one kind of a subterfuge. Of course, Bombay High Court and several other high courts have said that you cannot indulge in such a practice, because this is trying to indirectly subvert the law, or they sell away the machines. There are any number of writ petitions which have been filed by workers and trade unions telling asking the courts to prevent managements from selling away machines. Because managements just shut shop and disappear. They sell away the machine, sell away everything and disappear, and the workers are left looking at locked doors with all their dues pending. So this is the reality that most workers face, and of course once you raise a dispute, even if you get benefits, whether you can actually execute it, whether you can realize those benefits is another, the practical story is very different from what the law says. But at any rate, if you need to face this reality, you need to know what the law is and see how best you can use the law as a tool to help the workers to whatever extent you can, or to guide the management to ensure that by and large they also take care of the interests of the workers, so that nobody is left high and dry and nobody gets an unfair deal of this entire economic venture. So I think with this I have given you a broad framework of the Industrial Disputes Act and the machinery under it. Of course there are other aspects with regard to section 9 capital A and other nuances, but that may not be required. So maybe if there are any questions I can take it from there. Yes, yes. See, Workmen's Compensation Act is essentially for compensating the workers for injuries or death suffered in the course of employment. So it is not an industrial dispute in that sense of the term. It is a separate enactment which is only providing for that, and if an industry is covered under the ESI Act, then your workmen's compensation will not come into play. And ESI today in a way is much more comprehensive, because the worker is not only getting medical assistance, but you also get your monthly wages during the period when you are not working. It also provides, the ESI Act also provides for it. So Workmen's Compensation Act is a completely different enactment. It is revenue recovery proceedings. You will get a certificate. So supposing you need to recover, it is like you need to get a certificate from the revenue department, and then they can go and seize the vehicle. Japti pandradda. They can seize the machinery, whatever assets, sell it and realize and give it the money to you. So that is execution proceedings. See, the settlement, you can stipulate the period of the settlement within the act, within the settlement itself. You can say that the settlement, the maximum period you can, if there is no maximum period stipulated in the settlement, then the act provides for I think 6 months or 1 year for the settlement section 18. But it can be inbuilt, the clause can be inbuilt that the settlement will be valid for a period of 5 years. You can stipulate it, yes. Any other question?
Works for nearly 475 days. How many days to be given break service? We break for continuous service.
No, you shouldn't give ideally breaks.
How many? Is there any gap? Days, number of days?
No, there is no.
2 days. If you say in Chennai corporation, they are making only 89 days. Like that, is there?
See, that is illegal. See, it's actually, I think they are just fooling themselves, because there is no legal sanctity to it. Merely because you are employing somebody for 89 days, it doesn't mean that the labor laws don't apply. It is actually a very fool. In fact, Supreme Court has also come down very heavily on this practice of 89 days. It is basically leaving the workers in a very vulnerable situation, but it really doesn't have any legal sanctity, because all that is required is in 12 calendar months, 24 to 40 days. So the number of breaks doesn't really, or actually it's very sad, but even in our High Court, if you go to the City Civil Court, the City Civil Court staff, I don't know how many of you know, the stenographers and many of the clerical staff in our City Civil Court are given these artificial breaks. Can you believe it? It's happening in our campus. They are given a break for every 2-3, I think at the end of every 3 months, they are given a break for 3 days or 4 days and then re-employed again. No, I'm saying there's no question of enough. That 3 days itself is illegal. That those are all artificial breaks which actually don't count. You need to count those 3 days also as part of, because it is not a break where the work has come to an end. It is a break which is being artificially introduced by the employer. So these artificial breaks have been frowned upon by the Supreme Court, and these are not valid. So even if you give 3 days or 4 days break, the worker can claim to be in employment even for those 3 days. I think that you will have to go back to I think you will have to go back to the Industrial Revolution and the whole issue of you had no, because the Trade Unions Act actually goes back to the industrial dispute. So that whole concept of trade and the union, at least not in a legal. See, it is legally, I really, because it is really a historical reason, because going back to the Industrial Revolution in England, you had these trade guilds, where you had workers' guilds which were working with each specialization. I think it's in that historical context that the term evolved. But that is my broad understanding. I really don't have a direct answer for you. See, under the minimum wages, you have the Minimum Wages Act. So you have an authority under the Minimum Wages Act. So it's easier for you to file a petition before the authority under the Minimum Wages Act. Because since it's a special enactment with a special officer to look into that aspect, it's easier for you to access that than to come to the Labour Court. In fact, the courts have said that you must, if there is a special act which provides for its own machinery, then you should only approach the machinery under that act. But you can raise a general wage dispute, not a minimum wages dispute, but supposing you feel that a particular level of wage is not sufficient and there is a general demand for higher wages by the workers, that can form part of your charter of demands and it can be a subject matter of dispute under the Industrial Disputes Act. But as far as minimum wages or non-payment of minimum wages is concerned, you can go before the Minimum Wages Authority.
It was just not merely a bird's eye view. We got a deep insight into the development origin of labor law, and the way she was able to connect the Supreme Court judgments and the various amendments was really outstanding. We thank her for the wonderful lecture. Thank you. Tomorrow I think it's going to be a lecture by Mr. K.M. Vijayan. And the subject is going to be fundamentals of writ practice, which again I think is going to be very useful to lawyers, particularly those lawyers who have not been practicing on the High Court, and the youngsters who are going to come in. And today, I think you can file writ petitions for practically everything. So it's going to be a very interesting lecture. So I request all of you to come in good strength and take benefit.